Linda, with more than 30 years of federal criminal appeal experience, what would you say makes a strong appeals case?
Well, it's important to remember as you approach a federal criminal appeal that it's not a do-over of the trial. We're not looking at the facts anymore. We're focusing only on legal error. So when I take a criminal appeal, I examine any transcript, I examine pretrial motions, rulings on those motions, possible evidentiary errors, errors in the jury instructions, and things like that. We're no longer talking about the facts, we're only focused on legal issues.
I think that's important to understand, that this is not a trial all over again, but very narrow, certain legal errors. What are the legal errors you would consider call for an appeal?
Frequently, that might be the denial of a motion to suppress, where the court admitted evidence that should never have come in that affected the outcome of the trial. We frequently see issues in the jury instructions, the way the jury is instructed on the law. That can be a possible grounds for a viable appeal.
So for you, when you approach and analyze a federal criminal appeals case, first and foremost, beside obviously talking with the client, is you study, really study carefully the transcript from the trial. Is that correct?
I do. In fact, all I look at is the record. We can't look outside of the record. That's all that the Court of Appeals will have, is the transcript, the rulings, the paper filings. So as an appellate lawyer, that's all I can look at in deciding whether there are issues for appeal.
Now, for our audience, it's not always clear, do I have a strong case? Do I have any case? If somebody is uncertain upon a conviction, do you offer your expertise to anyone going through the stage of a federal criminal trial?
Yes, I frequently consult on legal issues along the way because it's very important to preserve the record along the way, and that is to make the correct motions, arguments, and pursue the correct course in order to have a viable issue if the defendant ultimately loses at trial.